Hi everybody, Derek Christensen here. I'm the owner of Legion Law, a premier estate planning and probate law firm in Dallas, Texas. Today I wanted to talk about what happens if you forget to mention your children and you pretermit the child from your will. But before I dive into that, let me tell you how to reach out to me. You can email me directly, Derek, D-E-R-E-K, at legionlawpllc.com, or you can find me on my website, www.legionlawpllc.com. So with that, let's dive right in. So, in this circumstance, this is called a pretermitted child. I don't think the captions are going to pick that up, but pretermitted means that it is possible this child was forgotten on accident and excluded from the will whenever the children were supposed to be included in the will. Now, there's really only one scenario in which a pretermitted child is going to come into effect. We have a child who is born after the signing of the will. That is the most important factor. Was that child born after the signing of the will? The second most important factor is, does the will address what happens if a child is born after the will? If the answer is yes, the child is born after the will was signed, and no, there is nothing inside the will that discusses what happens if there's a post-will child born, then you have this situation, the pretermitted child situation. If you have this situation, what's going to happen is the government will say, all right, you either receive the share, or you receive what everyone else would have received under the will, or all the other children would have received under the will, or you receive whatever share you would have received under the default laws of Texas that go to children. So it gets real complicated real quick. It's not very fun, but at the end of the day, for an example, if I wrote a will and I had a child, I have 3 kids. I say in my will, I say everything is going to go to my children in 3 equal shares. Actually, I say 1/3 to A, 1/3 to B, 1/3 to C. That's all I say. I don't say everything to my children. I just say A, B, and C. So if I had a child after the will, you have to understand that's after the will, and the will does not address what happens to the child who's born after the will. Therefore, we're in a pretermitted child situation. Now, in that situation, the child would be able to say, okay, well, I'm either entitled to what everyone else is receiving, so 1/3, but 4/3 doesn't make it good math. So in this circumstance, it would actually be whatever the default laws of Texas say, and the default laws say equal shares. So 25% would happen to everybody, even though it says in my will, A 1/3, B 1/3, C 1/3. See what I mean? But let's go back to that scenario. Let's say I have a will, I sign it, and then the day after a child is born, whatever. So I don't mention that child in my will, but if my will states all my children shall receive $10,000, and I'm going to give 10,000 to A, 10,000 to B, 10,000 to C, then in that circumstance, all of my children is going to address whether or not or how the post-will child is going to be treated. Therefore, that post-will child is obligated to take that 10,000. They cannot receive anything more. They can't claim, one child's getting more than the other and that's not fair, so I want that share. No, they have to do exactly what the will says, because the will says all my children without any kind of qualification. So if it says all of my children named in this will, that's a different story. And that's where the language really starts mattering. Mattering? Is that a word? My language needs to matter about mattering. But either way, it is very, very important to make sure that your will addresses what happens to any children that are adopted or born to you after you pass, or after you sign that will. You think you're not going to adopt any children. You think you're old and you're not going to have any more kids, but you just never know. And so it's always good to just cover your base on that front and be able to say, no, even if you are born after the will, even if you're not listed in the will, we are not going to let you come in and just bust everything up. You're treated just like every other child, and that's where, you get X number of dollars or whatever percentage, right? So it just depends on what you're trying to accomplish. But if you're specifically trying to disinherit a child, or you want to forget about that child and not give them anything, then there are ways to go about that as well. I've recommended this in the past, but you absolutely should name all your children in your will. And you should say, by the signing of this date, I know all of these children are mine, plus any other child that's currently, in incubation. I don't know what the phrase is, in gestation, where they are pregnant. You know, where the mother is pregnant and she's carrying the child. So you'd want to list that as well in the will. But of course, you know, let's say 20 years down the road, a new child comes up, then of course you still want to make sure your language in your will addresses what happens if a new child comes out of the blue. Not fun, I know, and it sounds a little strange, and you know, your wife might give you a little a look on the side to say, do you have any other children I need to know about? But it is what it is, and it's very important to include, because again, if somebody pops up and says, oh yeah, I am, you know, a child of this estate, give me all the money, that's not going to be fun. So either way, if you're worried about bastard children ruining everything, or if you have any other questions about estate planning and probate, feel free to reach out. I'd be more than happy to help. I respond to email, so send me in one. It's Derek, D-E-R-E-K, at legionlawpllc.com. Or you can find me at my website, www.legionlawpllc.com, where you go to our Contact Us page, and you can schedule a free over-the-phone consultation directly on my calendar. So thanks for watching, and have a great day.